Hi, I'm firearms attorney Gilbert Ambler, and today we're here to talk about another win in the Fifth Circuit as it relates to pistol braces. And as always, before we dive into this subject, if you have not yet subscribed, go ahead, hit subscribe for us, like, comment, share. That way you and your friends can keep getting this important Second Amendment related content. Now, what we want to talk about is what the Fifth Circuit did in remanding Mock v. Garland, which was the challenge to the pistol brace rule in the Fifth Circuit that Firearms Policy Coalition brought. And when they remanded it back to the district court judge to consider the Administrative Procedures Act, the APA in short. And that was the basis for their ruling. They said this rule likely violates the APA, and so we're sending it back to you so that you can consider it with that guidance in place. The Administrative Procedures Act is statutory law, and as statutory law, it sets forth how the ATF needs to go about implementing new rules. And the big problem for the ATF on the pistol brace rule, it seems, was the departure from the prior worksheet that they used. When they circulated the proposed rule, they had, as you may remember, they had a worksheet that assigned various point categories to certain prohibited features or certain offensive features in the mind of the ATF on each pistol brace. And when you added all of those up, you would get a numerical sum that would tell you whether your brace pistol was lawful or unlawful. And of course, when the final rule was released, that worksheet was nowhere to be found. So that was the basis, was that this was not a logical outgrowth of the prior rule. Fifth Circuit said we need to send that back. Now, one of the judges wrote in his concurring opinion that he believed that the rule also violated the Constitution. And I know every gun owner out there was hoping the court would say, this is an unconstitutional rule, send it back, it violates the Second Amendment. And in fact, everyone was probably hoping that the court would say, in fact, as we look at this, the National Firearms Act actually violates the Second Amendment. And that's probably not going to happen. Why is that not going to happen? Not because it's not true, but because of the doctrine of constitutional avoidance. There's a doctrine out there that says judges, if they can avoid answering a constitutional question, if a case can be decided on either statutory grounds or constitutional grounds, that judges should always defer to and decide the case on the statutory grounds. In this case, the Administrative Procedures Act, the APA, which means the pistol brace rule, while likely to be undone by the court based on a violation of the APA, is probably not going to provide us with any groundbreaking Second Amendment constitutional law, nor is it likely to undo the NFA, because judges will avoid the constitutional question based on these rules of constitutional avoidance, meaning they're supposed to avoid the constitutional question. So how could we get a judge to address the constitutional issues? Well, the way that we could potentially get a judge to address the constitutional issues is by bringing a suit challenging the rule based only on the Constitution. Of course, there are logical problems with doing that. And the logical problems, as a legal matter, you could get a judge to address the constitutional issues if that was your only claim. The logical problem is, as soon as somebody else files a lawsuit somewhere else, and in that other lawsuit elsewhere includes the Administrative Procedures Act, which is, of course, a valid grounds to challenge the law on. As soon as somebody else does that, then the judge, wherever you filed your constitutional claim, is probably going to stay your case to see whether the other judge decides it on the statutory grounds. So essentially, the only way we would likely get a constitutional argument where they undo the NFA and SBRs on the NFA because of the unconstitutional nature of the pistol brace rule would have been if no one brought an Administrative Procedures Act and only brought constitutional claims. And of course, no one wanted to do that because they wanted the best arguments and as many arguments as possible on why the rule should be struck down. And it's a very good argument, the Administrative Procedures Act. So when you have competing firearms rights organizations, FPC, GOA, 2AF, nobody wants to be left out of the party. So for example, I'm going to make this up because the NRA was late to the party, but assuming that the NRA had been in at the beginning, which they were not, but assuming the NRA had been in at the beginning, they would not want to have brought a constitutional only challenge and not gotten any help for their members when everybody else was bringing APA grounds. So one of the problems here is that because of all of the groups, and they're all doing a good job, most of them are doing a good job, but because of the multitude of groups challenging this, no one wants to be left out. So everyone's going to bring the APA violations. And once we have the APA violations, the court's not going to reach the constitutional violations. If you enjoyed this analysis or this explanation of constitutional avoidance and how it applies to the Fifth Circuit and the pistol brace rule, go ahead, share this video for us. Until next time.